All right, let's dive deep today. We're talking all about SCOTUS, the Supreme Court of the United States.
SCOTUS. Yeah.
Whether you're prepping for a meeting or maybe brushing up on your civics.
Or just really curious.
Yeah, or just super curious about this powerhouse, this legal powerhouse
Absolutely.
of American law.
It's a big one.
You are in the right place. We're going way beyond like just your usual kind of Wikipedia summary.
Yeah.
And trust me, it's about to get super interesting.
It is.
We're using excerpts from the Supreme Court's Wikipedia page. And by the time we're done, you'll not just know, like, the basics.
The basics.
We'll have some real insights into how SCOTUS works,
Right.
its history,
Yeah.
and the impact it has today.
I think what's so fascinating about the Supreme Court is just how deeply it's woven into, like, the fabric of our lives.
Right.
But most people only have a surface understanding of what it actually does.
Okay, so let's unpack that.
Okay.
It is the highest court in the land.
It is.
Sure, but what does that actually mean in practice?
What it means is they have the final say on cases involving the Constitution,
Right.
federal laws, and disputes between states.
Okay.
So think about it this way. If a case makes it all the way to SCOTUS, their decision is the end of the line.
Wow.
No more appeals.
No more appeals.
No more back and forth like what they say.
Yes. So they're kind of like the ultimate referees.
Yes.
Making sure everyone's playing by the rules.
Exactly. And here's where it gets really interesting.
Okay.
They can even strike down orders issued by the president
Whoa.
if they find those orders to be unconstitutional.
Really?
It's a powerful check on executive power.
That's a lot of power for 9 unelected people.
It is.
It kind of makes you wonder.
It does.
How did they get to be so powerful?
Right.
Like, it's not like they were always this influential, right?
You're absolutely right. The court wasn't always this powerful. In fact, early on, there was a lot of debate about how much authority it actually had. It wasn't until the landmark case of Marbury v. Madison in 1803 that the court really asserted its power of judicial review.
Okay, Marbury v. Madison, it's like the case everyone learns about in school.
Right.
But beyond the name, I'll admit, it's a little fuzzy.
Okay.
Can we break down why it was such a game changer?
So before Marbury v. Madison, it wasn't really clear that the court could actually invalidate laws passed by Congress if they found those laws to be unconstitutional.
Interesting.
So this case, it changed all that. It established the principle that the court has the ultimate authority to interpret the Constitution and determine whether laws are in line with it or not.
Okay, so Marbury v. Madison wasn't just about some, like, legal squabble.
Okay.
It was like a seismic shift in the balance of power in the U.S.
Exactly. It's hard to overstate its importance. It essentially gave the court the power to say, hold on, Congress, you can't do that. That violates the Constitution.
And that power has shaped American history ever since, hasn't it?
Oh, absolutely.
I mean, from desegregation to same-sex marriage.
Yeah.
So many landmark decisions
Oh, yeah.
hinge on this idea that the Supreme Court has the final say on what's constitutional.
You got it. Cases like Brown v. Board of Education, which struck down school segregation, and Obergefell v. Hodges, which legalized same-sex marriage nationwide, all stemmed from the court's power of judicial review, a power first established in Marbury v. Madison.
So from a somewhat shaky start,
Yeah.
SCOTUS rose to become this, like, legal titan.
It did.
Let's take a walk down memory lane.
Okay.
What are some of the most pivotal chapters in SCOTUS history?
Well, you can't really talk about SCOTUS history without mentioning the Marshall Court.
Right.
John Marshall served as Chief Justice from 1801 to 1835.
Okay.
And his tenure is considered like a defining era for the court. It's when they really started to like flex their muscles and solidify their influence.
Like what kind of influence? Give us some juicy detail.
Think about it this way. Back then, the relationship between the federal government and the states was still pretty fuzzy.
Okay.
Marshall's court helped define that relationship, often siding with the federal government.
Interesting.
And expanding its power.
Okay, so give us an example. What's a case that really exemplifies that expansion of federal power?
Take McCulloch v. Maryland in 1819.
Okay.
This case revolved around the Second Bank of the United States, which Maryland tried to tax.
Okay.
The court ruled in favor of the bank, stating that states couldn't interfere with legitimate federal activities.
Wow.
So this decision really solidified the idea that the federal government had powers beyond those explicitly listed in the Constitution.
Interesting. So it's like Marshall's court was laying the groundwork for a stronger, more unified nation.
Precisely.
And this emphasis on federal power continued to influence American law and politics for decades to come.
Oh, for sure, for sure.
Then came the Great Depression and FDR's New Deal programs, which I imagine presented a whole new set of challenges for the court.
Oh, the New Deal era was a tumultuous time for the court.
Right.
You had President Roosevelt trying to implement these sweeping economic reforms.
Okay.
And you had a court that was initially skeptical of federal intervention in the economy.
So it was like a clash of titans, the president versus the Supreme Court.
Exactly.
Wow.
And the stakes were incredibly high.
Right.
The nation was grappling with this unprecedented economic crisis. And Roosevelt's programs were seen as radical by some, necessary by others.
So how did that clash play out? Did SCOTUS try to block the New Deal?
Initially, yes.
Really?
The court struck down several key New Deal programs, arguing that they exceeded the federal government's authority.
So you're saying in the midst of a national crisis, you had the Supreme Court saying, nope, the president can't do that.
It was a tense situation. The court's decisions sparked a lot of controversy.
Okay.
Even led to talk of court packing.
Court packing.
Where Roosevelt would appoint additional justices to shift the balance in his favor.
Wow, that's intense.
Oh.
So what happened? Did Roosevelt actually pack the court?
He didn't have to.
Right.
The court eventually shifted its stance.
Really?
Upholding some key New Deal programs and adopting a more expansive view of federal power.
It's amazing how much power SCOTUS can wield, even in the face of a national emergency.
It is.
So we've got the Marshall Court setting the stage for a strong federal government.
Right.
Then the New Deal era, forcing a reckoning with the limits of that power.
Yeah.
What came next?
Well, after the New Deal, the court continued to grapple with a wide range of issues, from civil rights to criminal justice to environmental protection.
Wow.
And with each new era, new justices brought their own perspectives, philosophies, shaping the court's decisions, leaving their mark on American history.
It's kind of like watching a relay race. You know, with each generation of justices kind of passing the baton to the next. Building on the precedents of the past.
Right.
While also navigating the challenges of their own time.
That's a great analogy. And it highlights the dynamic nature of the court. It's not a static institution, but a living, breathing entity that's constantly evolving.
And that evolution continues today with the Roberts Court.
It does.
Which is tackling some of the most contentious issues facing our nation.
Absolutely. Issues like affirmative action, gun control, and campaign finance are all on the docket, with each decision potentially reshaping American law and society for years to come.
Okay, so we know SCOTUS has shaped history.
It has.
But how does one even become a Supreme Court justice?
Right.
It's got to be more complicated than just sending in your resume, right?
Think of it as like the Olympics of legal careers.
Yeah.
The selection process is incredibly rigorous and high stakes.
Wow.
It starts with the presidential nomination, which is already a huge honor. Then the nominee has to go through this intense vetting process, culminating in public hearings before the Senate Judiciary Committee.
I've seen those hearings on TV.
Yes.
They can be brutal.
We can.
With senators grilling the nominees on their past rulings, their judicial philosophy. It's like a legal trial by fire.
It's definitely not for the faint of heart.
Right.
The nominees are under intense scrutiny.
Yeah.
With their every word and action analyzed and debated.
And all of this plays out in the public eye, right?
It does.
It's not like a quiet behind closed doors process.
Exactly. These confirmation hearings have become increasingly high profile and politically charged in recent decades, with the media and advocacy groups playing a huge role in shaping public opinion.
Remember the Robert Bork nomination back in 1987? It really highlighted just how contentious things can get.
It did.
His nomination was ultimately rejected.
It was.
Largely due to his conservative judicial philosophy. And his role in the Watergate scandal.
Bork's nomination was a turning point.
Okay.
It demonstrated the growing influence of ideology and political maneuvering in the confirmation process. It also showed just how high the stakes are.
And speaking of high stakes, didn't the Senate recently change the rules to make it easier to confirm Supreme Court nominees?
You're thinking of the elimination of the filibuster for Supreme Court nominations.
Okay.
Before that change, it took 60 votes in the Senate to overcome a filibuster.
Right.
And bring a nominee to a vote.
Right.
Now it only takes a simple majority.
Wow.
Which means the party in control of the Senate has a much easier time confirming their nominees.
So it's become even more of a political battleground.
You could say that the confirmation process is now less about consensus building and more about raw political power.
Wow. It's no wonder those hearings can get so intense.
It's true.
So let's say you've navigated that gauntlet.
Okay.
And you've landed this coveted seat on the Supreme Court.
All right.
What's life like as a justice? Is it all fancy robes and gavels?
Well, there are definitely robes and gavels involved.
Right.
But it's far from a ceremonial role.
Okay.
Justices work incredibly long hours.
Right.
They're constantly reading legal briefs.
Okay.
Preparing for oral arguments. Writing opinions.
And they have lifetime tenure, right?
They do.
Once they're appointed, they're basically there for life, right?
That's right. They serve until they choose to retire, pass away,
right,
or in very rare cases are impeached and removed from office.
That's a pretty unique system.
It is.
I mean, most judges in other countries don't have that kind of job security.
It's one of the things that sets the U.S. Supreme Court apart.
Right.
This lifetime tenure. It's meant to protect the court's independence, shielding it from political pressure, allowing justices to make decisions based on the law, not on fear of losing their jobs.
But it also means that unpredictable vacancies can dramatically alter the court's composition.
Yes.
And ideological balance over time.
It's true.
Like one retirement or unexpected death could suddenly shift the balance of power on the court.
Exactly.
It also raises questions about aging justices, right?
Yes, it does.
I mean, there's no mandatory retirement age.
There isn't.
So what happens if a justice becomes incapacitated?
Yeah.
Or just isn't able to keep up with the demands of the job?
It's a sensitive topic.
Right.
While there are mechanisms for addressing a justice's inability to perform their duties, they've rarely been invoked.
Wow.
It's a very delicate situation, you know, balancing the need to ensure that the court can function effectively with the respect due to a justice's lifetime appointment.
And just to clarify, impeachment is incredibly rare.
Right. In the entire history of the Supreme Court, only one justice has ever been impeached.
Wow.
Samuel Chase, back in 1804.
Right.
And even he was acquitted by the Senate.
So impeachment's more of a theoretical check on the court's power than a practical one.
It is.
Okay, let's move on to the makeup of the court.
Okay.
How many justices are there?
All right.
And what does the current composition look like?
The court consists of 9 justices.
Okay.
1 chief justice who leads the court.
Right.
And 8 associate justices.
Okay.
The current composition is particularly interesting because we have a 6-3 conservative majority, meaning that conservative justices are likely to control the outcome of most decisions.
So every case, every ruling carries even more weight, knowing that the court leans in a particular direction.
Oh, absolutely.
And it's not just about ideology, right? We've seen some shifts in the court's makeup in terms of diversity as well.
Absolutely.
Like religiously and racially and in terms of gender.
The court has become more diverse over time, both in terms of religious representation and gender. While it was historically dominated by Protestant men, we've seen a shift toward a more balanced representation of Catholics and Jews.
And of course, we've had some groundbreaking appointments in recent years.
We have.
Like Sonia Sotomayor, the first Hispanic justice.
Yes.
And Ketanji Brown Jackson, the first African-American woman to serve on the court.
These appointments are significant not just for their symbolic value, but also because they bring new perspectives and life experiences to the court, potentially influencing its decisions on a range of issues.
Okay, so we've got a 9-member court, a 6-3 conservative majority, and increasing diversity.
We do.
But how does SCOTUS actually work in practice?
Yeah.
Like, how do they decide which cases to hear?
Right.
And what's the process like once a case lands on their docket?
Think of it like a carefully choreographed dance.
Okay.
With each step meticulously planned and steeped in tradition.
I like that. Okay, so what's the first move in this judicial ballet?
It all starts with what's called a cert petition.
Okay.
Which is a formal request asking the Supreme Court to review a case. Keep in mind that SCOTUS receives thousands of these petitions each year.
Wow.
But they only agree to hear a tiny fraction of them.
Wow. Talk about an exclusive club. What determines whether a case gets the green light?
There's no, simple formula.
Right.
Justices generally look for cases that involve significant legal issues, conflicting rulings from lower courts, or questions of national importance.
So it's not just about the specific facts of the case,
No,
but about the broader implications for the legal system and for society as a whole.
Exactly. Justices are looking for cases that will allow them to, clarify the law, resolve disputes among lower courts, or address pressing social issues.
Okay, let's say a case catches their eye and they decide to hear it.
Yeah.
What happens next? Do the lawyers just show up with their briefcases and start arguing?
Not quite. So if the court grants certiorari, the case moves into a more formal stage. Both sides submit written legal arguments, outlining their positions and citing legal precedents to support their claims.
So it's a battle of legal briefs.
It is.
With each side trying to persuade the justices with their written argument.
Yes, it's a crucial part of the process.
Okay.
These briefs are meticulously crafted and often run hundreds of pages long.
That sounds like a lot of reading for the justices.
It is, but they don't have to tackle it alone. This is where their law clerks come in.
Ah, yes. The famous law clerks.
Yes.
Tell us more about these legal whiz kids and the role they play.
So law clerks are typically recent law school graduates who have distinguished themselves academically and clerked for lower court judges. They're selected through a highly competitive process, and only a handful are chosen each year to work for the Supreme Court justices.
So they're like the Justice League of legal minds.
You could say that.
Okay, break it down for us.
Okay.
What do these legal superheroes actually do?
Their duties are varied and demanding. They research legal issues, draft opinions, prepare memos, and help justices prepare for oral arguments.
So they're like the justices' right-hand assistants, right?
They are.
Trusted advisors who help them navigate the complexities of the cases before them.
Exactly. They're a vital part of the court's machinery.
And they even play a role in selecting which cases the court agrees to hear.
That's right. Some justices pool their law clerks to review the cert petitions, which is why it's called the cert pool. They essentially act as gatekeepers, making recommendations to the justices about which cases are worthy of the court's attention.
Wow, talk about responsibility.
It is.
I can't imagine having that much influence right out of law school.
It's an incredible opportunity.
Yeah.
It's also a testament to the trust that justices place in their law clerks.
So after the briefs are submitted and the law clerks have done their due diligence, what happens next? Do the lawyers finally get to make their case in person?
That's right. The next stage is oral arguments. Where lawyers from both sides present their cases before the justices, who have the opportunity to ask questions and probe their arguments.
So it's like the main event.
It is.
The courtroom showdown where all the legal arguments come to a head.
Exactly. And while it's not quite as dramatic as what you see on TV, it's still a very high-stakes affair. The justices can interrupt the lawyers at any time to ask questions, challenge their assertions, or clarify points of law.
And these oral arguments are open to the public, right?
They are.
So theoretically, anyone could just go and watch.
In theory, yes. But getting a seat for a high-profile case can be incredibly difficult.
Imagine.
People camp out overnight.
Wow.
Or enter lotteries for a chance to witness history in the making.
It's like getting tickets to a sold-out concert or something.
It is.
Okay, so the lawyers have presented their cases. The justices have grilled them with questions. The courtroom drama has reached its peak. What happens next?
After the oral arguments are over, the justices go into their most secretive phase.
Deliberation.
Yes. Okay, what's that all about?
Yeah.
Do they just lock themselves in a room and just start arguing with each other?
Well, it's a bit more civilized than that. So the justices meet in private to discuss the case. Weigh the arguments presented by both sides. And ultimately vote on the outcome.
So it's a majority rules situation.
It is.
Whoever gets the most votes wins.
Exactly. The majority decides the case.
And one justice from the majority is assigned to write the court's opinion. Which explains the rationale for their decision.
So the votes are tallied, the opinion is written, and the case is decided.
Yeah.
It's at the end of the line.
Not quite.
Okay.
Once the opinion is circulated among the justices, there's still room for, like, negotiation and revision.
Okay.
Justices who disagree with the majority opinion can write dissenting opinions.
Interesting.
Outlining their objections and offering alternative interpretations of the law.
So even though the case is technically decided,
yes,
the debate can continue through these written opinions.
Absolutely. These dissenting opinions, they're an important part of the process.
Right.
They can influence future legal thinking.
Interesting.
And sometimes a dissenting opinion can even lay the groundwork for overturning a precedent down the road.
It's like planting a seed.
Yes.
For future legal change.
Exactly.
So the decision is announced, the opinions are published, and that's it. The case is closed.
Right.
But we all know that SCOTUS doesn't exist in a vacuum, right?
It doesn't.
Their decisions have real-world consequences.
They do.
Sparking debates and impacting the lives of everyday Americans.
That's a crucial point.
Yeah.
The Supreme Court's rulings don't just sit on a shelf gathering dust.
Right.
They shape our laws, our policies, and the very fabric of our society.
And that brings us to one of the most fascinating and often controversial aspects of the Supreme Court. The criticisms and debates that swirl around its decisions and its role in American society.
The court is often at the center of heated debates about everything from individual rights to the balance of power between the federal government and the states.
And it's not just about the decisions themselves, right?
No.
There are also questions about the court's power, its legitimacy, and even the ethical conduct of the justices.
You're absolutely right.
Yeah.
With great power comes great scrutiny.
That's right.
And the Supreme Court is certainly no exception.
Okay, let's dive into some of these criticisms and controversies.
Okay.
What are the hot-button issues that tend to stir up the most debate?
Well, one of the biggest areas of contention involves the court's power of judicial review, which, as we discussed earlier, allows it to strike down laws passed by Congress or even presidential orders.
We talked about how Marbury v. Madison established that power.
Right.
But why is it so controversial?
Critics argue that it gives unelected judges too much power.
Okay.
And undermines the democratic process.
So it's a question of who gets to decide what's constitutional.
Yes.
The people's elected representatives?
Right.
Or the justices on the Supreme Court?
Exactly. And it's a debate that has raged since the founding of the Republic.
But supporters of judicial review argue that it's a vital check on the power of the other branches of government.
They do.
Right. That it's necessary to protect individual rights and prevent tyranny.
That's the core of their argument. They point out that the Constitution was designed to prevent any one branch of government from becoming too powerful. And they argue that judicial review is essential to ensure that the other branches stay within their constitutional limits.
It's a tricky balance, isn't it?
It is.
Finding that sweet spot between upholding the will of the people as expressed through their elected representatives and safeguarding individual rights from potential government overreach.
It is. And the Supreme Court is constantly navigating that tension, weighing competing interests, and making decisions that shape the course of American history.
Speaking of navigating tension, another major area of controversy involves the concept of judicial activism. Judicial activism.
Judicial activism.
It's a term that gets thrown around a lot.
It does.
But it's often misunderstood.
It is.
So can we clear the air?
Okay.
What does judicial activism actually mean?
At its core, it refers to the idea that judges should actively use their power.
To shape social policy and protect individual rights, even if it means going beyond the literal text of the Constitution or overturning laws passed by elected officials.
It's about judges taking a more proactive role.
Yes.
Not just interpreting the law, but actively shaping it to address social issues or protect individual rights.
And this approach is often contrasted with judicial restraint, which emphasizes a more limited role for the courts, focusing on interpreting laws as they're written rather than making new law.
But why is judicial activism so controversial? What are the arguments against it?
Critics of judicial activism, they argue that it gives unelected judges too much power, essentially allowing them to legislate from the bench and impose their own personal or political views on the nation.
Like they're overstepping their bounds, right?
Yeah.
Acting more like lawmakers than interpreters of the law.
Exactly. And they worry that this undermines the democratic process.
You know, as unelected judges make decisions that should be left to the people's elected representatives.
But supporters of judicial activism counter that the courts have a duty
Yes.
to protect individual rights.
Yes.
Especially those of minority groups.
Absolutely.
Who might not have the political power to advocate for themselves through the legislative process.
That's a key argument in favor of judicial activism. Proponents point to landmark decisions like Brown v. Board of Education, which desegregated schools, and Roe v. Wade, which legalized abortion, as examples of the court stepping in to right historical wrongs and protect fundamental freedoms that were being denied by the political process.
So it's a debate about the role of the court in a democracy.
It is.
Should it be a guardian of individual rights, even if it means striking down laws passed by elected officials?
Right.
Or should it defer to the will of the majority and avoid imposing its own values on society?
It's a complex issue with no easy answers. And it often comes down to a matter of perspective and interpretation.
And the debate often falls along ideological lines, doesn't it?
Often, yes.
With conservatives generally favoring judicial restraint.
Yeah.
And liberals tending to support a more activist role for the courts.
That's a common observation, and there's certainly some truth to it, but it's not always so clear-cut. You know, there are conservatives who support judicial activism in certain cases, like involving religious freedom or property rights. And there are liberals who advocate for judicial restraint when it comes to economic regulation or national security.
So it's not as simple as drawing a line in the sand and saying, this is judicial activism and this is judicial restraint.
Exactly. It's a nuanced debate that requires careful consideration of the specific facts of each case, the relevant legal precedents, and the potential consequences of a judicial decision.
Okay, so we've got this ongoing tension between judicial activism and judicial restraint.
We do.
How does that play out in the context of the Supreme Court's current composition with its conservative majority?
That's a crucial question.
Yeah.
The court's ideological balance has a significant impact on its approach to judicial activism.
Okay.
So, with a conservative majority, we've seen a greater emphasis on judicial restraint in certain areas.
Okay.
Like economic regulation and environmental protection.
So less willingness to overturn laws passed by Congress or state legislatures.
Right.
Even if those laws are controversial.
Yes, that's generally the trend, but it's not absolute.
Right.
We've also seen instances where the conservative majority has been willing to overturn precedents or strike down laws that they view as unconstitutional, even if those actions are perceived as activist.
Like the recent decision to overturn Roe v. Wade. Ending the constitutional right to abortion.
Right.
That was a huge decision.
It was.
A major departure from precedent.
It was.
And it was driven by the court's conservative majority.
That's a prime example of how the debate over judicial activism can be complex and often defies easy categorization.
Right.
You know, it's not just about left versus right. Or liberal versus conservative. It's about how justices interpret the Constitution, their view of the court's role in society, and their understanding of the balance of power in a democracy.
So the court's current composition has definitely tilted the scales.
It has.
Towards judicial restraint in some areas.
It has.
But it hasn't eliminated judicial activism altogether.
That's a fair assessment.
Yeah.
And it's likely that the debate over judicial activism will continue to rage as the court grapples with the complex legal and social issues of our time.
It's fascinating, isn't it?
It is.
How this debate keeps playing out. How the court adapts to new challenges and how its decisions continue to shape the legal and social landscape of America.
It is. And it underscores the importance of staying informed and engaged in the ongoing conversation about the role of the judiciary in American democracy. You know, we need to understand how the court works, the factors that influence its decisions, and the potential consequences of those decisions for our lives and our society.
Well said.
Thank you.
Okay, ready to switch gears again?
I am.
This time we're diving into a topic that's been generating a lot of buzz lately.
All right.
The idea that the Supreme Court is outdated and in need of reform.
It's a topic that's been simmering for a while, but it's definitely reached a boiling point in recent years.
Okay.
There's a growing sense among some that the court, with its lifetime appointments, lack of term limits, and its increasingly partisan nature, is out of step with modern America.
Okay, let's unpack that.
Okay.
Why do some people believe that the Supreme Court is out of touch with the realities of 21st century America?
Well, one of the main criticisms is that the court's structure with its lifetime appointments creates a system where justices can serve for decades, potentially becoming detached from the evolving values and needs of society.
It's like having a group of legal sages from a bygone era making decisions that affect the lives of people living in a completely different world.
That's the concern of many critics. They argue that the court's composition doesn't reflect the diversity of the nation, and that its decisions often seem out of sync with contemporary social norms.
And the fact that justices are appointed by presidents and confirmed by the Senate, both inherently political processes,
they are,
adds another layer of concern, doesn't it?
Absolutely.
It raises questions about whether the court is truly independent or whether it's simply a reflection of the political ideologies of the presidents who appoint the justices.
Critics argue that this politicized appointment process leads to a court that's more focused on ideology than impartial justice. They worry that the confirmation process has become a partisan battleground, with nominees chosen more for their allegiance to a particular political party or ideology than for their legal expertise or their commitment to fairness and impartiality.
So we've got concerns about lifetime appointments, lack of diversity, and politicization.
We do.
What are some of the specific reforms that have been proposed to address these concerns? What are people suggesting we do to make SCOTUS more reflective of modern America and more responsive to the needs of the people?
One of the most commonly proposed reforms is to introduce term limits for Supreme Court justices. The idea is to limit their tenure to a set number of years, maybe 18 or 20, rather than allowing them to serve for life. So proponents of term limits argue that this would ensure a regular turnover of justices, bringing fresh perspectives to the court, and preventing any single justice from wielding undue influence for an extended period of time.
It seems like a straightforward solution.
It does.
It would create a more predictable and regular process for appointing justices, potentially reducing the stakes of each appointment and de-escalating the partisan battles that often surround the confirmation process.
Exactly. Supporters of term limits believe that it would make the court more responsive to the changing times and more reflective of the evolving values of society. They argue that it would help to depoliticize the court and make it more accountable to the people.
But as we discussed earlier, wouldn't term limits require a constitutional amendment?
It would.
And that's a pretty high bar to clear.
It is, requiring a supermajority vote in both houses of Congress and ratification by 3/4 of the states.
So it's not something that's likely to happen overnight?
It's a challenging process, and it's unlikely to happen without a sustained and widespread public demand for change. However, the fact that it's being discussed so seriously is a sign that there's a growing sense that the court needs to adapt to the realities of the 21st century.
So if term limits are a long shot, what are some of the reform ideas that might be more feasible in the short term?
Another proposal that's been floated is to expand the size of the Supreme Court, adding more justices to create a more diverse and representative body. So supporters of this idea argue that a larger court would be more likely to reflect the demographic and ideological diversity of the nation, and that it would be less susceptible to the influence of any single justice or block of justices.
This is what President Franklin D. Roosevelt tried to do back in the 1930s, wasn't it?
Yes, it was.
His court packing plan was met with fierce resistance and ultimately failed.
It did.
But the idea has resurfaced in recent years, fueled by concerns about the court's current ideological imbalance and its perceived lack of responsiveness to the needs of the people.
Exactly. So the court packing plan was seen by many as a partisan power grab, an attempt by Roosevelt to tilt the court in his favor and ensure that his New Deal programs
Right.
would be upheld.
Go on.
But supporters of expanding the court today argue that it's a legitimate way to address the court's current shortcomings and to make it more representative of the American people.
Right.
They point out that the size of the court has changed throughout history and that there's no constitutional requirement for 9 justices.
But wouldn't expanding the court just further politicize the judicial branch?
It's possible.
Like, wouldn't it lead to a tit-for-tat escalation?
Yeah.
With each party trying to pack the court with its own ideologically aligned justices whenever it gains control of the presidency and the Senate.
That's a valid concern.
Right.
Opponents of court packing argue that it would erode public trust in the judiciary and turn the court into a political battleground.
Right.
They fear that it would undermine the perception of the court as an impartial arbiter of the law and would further erode public confidence in the institution.
It's a tough call, isn't it?
It is.
On one hand, the court's structure does seem outdated in some ways.
Yeah.
And its decisions have a profound impact on our lives, whether we like it or not.
They do.
But on the other hand, tinkering with its composition could have unintended consequences.
It could.
And further erode public confidence in its legitimacy.
It's a complex issue with no easy answers.
Right.
And it's one that will likely continue to be debated as the court grapples with the challenges of the 21st century.
Well, it's a debate worth having, isn't it?
It is.
It forces us to confront fundamental questions about the role of the judiciary in American democracy.
Absolutely.
And the best way to ensure that the Supreme Court remains a beacon of justice and a guardian of our constitutional rights.
I couldn't agree more.
Right.
It's a debate that requires careful consideration, reasoned discussion, and a deep understanding of the court's history, its current challenges, and its potential for both good and harm.
Well said.
Thank you.
Okay. Ready to explore another facet of the Supreme Court that often gets overlooked.
Right.
This time we're going behind the scenes to meet the unsung heroes of the Supreme Court.
All right.
The law clerks.
Ah, yes.
The law clerks.
The law clerks.
They're the brilliant young legal minds
Yeah.
who play a crucial but often invisible role
Yes.
in shaping the court's decisions.
They're crucial.
I imagine it's kind of like being a legal apprentice to some of the most powerful legal minds in the country. Getting a front row seat to the inner workings of the highest court in the land.
It is.
Yeah.
Law clerks are typically recent law school graduates who have excelled academically and clerked for lower court judges. They're selected through a highly competitive process. And only a handful are chosen each year to work for the Supreme Court justices.
So what makes these clerks so special?
Yeah.
What qualities are the justices looking for in their clerks?
They're looking for the best of the best. So top-tier law school graduates who have demonstrated exceptional analytical skills, legal reasoning, and writing abilities. They also look for clerks who are intellectually curious, hardworking, and discreet.
Discreet. Why is that so important?
Because clerks are privy to confidential information and internal deliberations. So they need to be trustworthy and able to maintain confidentiality.
It's not just about legal brilliance.
No.
It's also about character and judgment.
It is.
What exactly do these legal whizzes do? What's a typical day like for a Supreme Court law clerk?
Their duties are varied and demanding. They research legal issues, analyze precedents, draft opinions, prepare memos, and help justices prepare for oral arguments.
They're kind of like the justices' right-hand assistants, aren't they?
They are.
Trusted advisors who help them navigate the complexities of the cases before them?
Exactly. They're a vital part of the court's machinery, and their work can have a significant impact on the court's decisions, even though they operate largely behind the scenes.
And we touched on this earlier, but it's worth emphasizing again. Law clerks even play a role in selecting which cases the court agrees to hear.
They do. That's right. Remember we talked about the cert pool? Where some justices pool their law clerks? To review petitions for certiorari.
Those petitions.
Yes.
Asking the court to hear a case.
Well, law clerks in the cert pool play a key role in screening those petitions. And making recommendations to the justices about which cases are worthy of the court's attention.
It's mind-blowing to think that someone so early in their career
It is.
could have such an impact on the cases SCOTUS chooses to hear.
It really speaks to the level of talent and dedication these clerks possess. They're the unsung heroes of the Supreme Court,
Right.
working tirelessly behind the scenes
Right.
to ensure the smooth function of this incredibly complex institution.
But there's been some debate lately
Yeah.
about the role of law clerks, hasn't there?
There has.
Some critics worry that they have too much influence,
Yeah.
that they might be injecting their own ideological biases into the court's decisions.
Right.
What do you make of that argument?
It's a valid concern.
Okay.
You know, there's always the potential for anyone's personal views to influence their work. And law clerks, with their relative youth and exposure to current trends in legal academia,
Right.
you know, might be particularly susceptible to this.
So the fear is that a justice's clerk might steer them toward cases
Yeah.
or legal arguments
Right.
that align with the clerk's own personal views,
Right.
even if those views differ from the justice's.
Right.
Right.
And some critics argue that this potential for ideological bias has contributed to the court's increasing polarization
Okay.
as justices surround themselves with clerks who share their worldview. This could potentially amplify existing ideological divisions within the court.
That's a worrisome thought.
It is.
But isn't it also possible that law clerks are simply doing their jobs,
It is, yeah.
providing research and analysis to help justices make informed decisions?
Right.
I mean, they're not pulling legal arguments out of thin air, are they?
Of course not. It's important to remember that law clerks
Yeah.
are highly skilled legal professionals
Right.
who are carefully vetted and chosen for their intelligence,
Right.
their analytical abilities, and their commitment to the law.
Right.
They're there to assist the justices,
Right.
not to dictate their decisions.
And the justices are ultimately responsible for their own decisions.
Rawr.
They're not just rubber stamping.
Yeah.
They're clerks' recommendations.
No.
They're experienced judges who have their own legal philosophies and their own understanding of the Constitution.
Exactly.
They're not going to be swayed by a clerk
Right.
who happens to have a different perspective.
The justices rely on their clerks for assistance, but they're the ones who make the final calls.
Right.
They weigh the arguments, consider the precedents, and ultimately decide how to apply the law to the specific facts of each case.
Okay, so we've got this intricate system of briefs,
Yes.
arguments, deliberations,
Yeah.
and opinions,
Yes.
all shaped by the justices' interpretations of the law
Yeah.
and the influence of their clerks.
It is.
It's a fascinating glimpse into how SCOTUS operates,
It is.
how this legal sausage gets made, so to speak.
It's a complex process, but it's designed to ensure that the court's decisions are well-reasoned, grounded in the law,
Right.
and ultimately reflective
Yeah.
of justice's best understanding of the Constitution
Right.
and its application to the issues of our time.
And speaking of issues of our time, let's talk about another area
Okay.
where the court plays a crucial role
Okay.
shaping American federalism.
Right.
It's a topic that often gets overshadowed
It does.
by more headline-grabbing issues,
It does.
like abortion or gun control.
Yeah.
But it's fundamental
It is.
to how our government functions,
It is.
how power is divided
Yes.
between the federal government and the states.
Federalism is at the heart of the
Yeah.
American experiment. It's the idea that power is shared between a national government and regional governments, creating a system of checks and balances that prevents any one level of government from becoming too powerful.
It's like a delicate dance, right?
It is.
A constant negotiation between the federal government, which seeks to assert its authority on matters of national importance, and the states, which jealously guard their own sovereignty.
They do.
And their right to govern their own affairs.
Exactly. And the Supreme Court often finds itself in the middle of this tug of war, interpreting the Constitution to determine where the lines of power should be drawn, what issues fall under federal jurisdiction, and what issues are left to the states to decide.
So how has the court approached this challenge over the years? What are some of the key decisions that have shaped the balance of power between the federal government and the states?
Well, we've already touched on some landmark cases from the Marshall Court, like McCulloch v. Maryland and Givens v. Ogden, which expanded the power of the federal government in the early 19th century. These cases established the principle of federal supremacy.
Right.
The idea that federal law trumps state law when the two conflict.
Yeah.
And they laid the groundwork for the growth of federal power in the centuries that followed.
Right. McCulloch upheld the constitutionality of the national bank.
Yes.
Establishing the implied powers of the federal government.
Right.
And Gibbons affirmed Congress's broad authority.
It did.
To regulate interstate commerce.
Yes.
Setting the stage for the expansion of federal power into areas
exactly
like transportation, communication, and even civil rights.
Those decisions were pivotal in shaping the relationship between the federal government and the states. They established like the basic framework for American federalism.
Right.
But the balance of power has shifted over time.
Right.
And the court has continued to play a crucial role in defining the boundaries of federal and state authority.
But there have also been periods where the court has pushed back against federal overreach.
Right.
And sought to protect the powers of the states. Right.
Well, there have.
Like, it hasn't always been a one-way street towards greater federal power.
Absolutely.
Right.
So in the late 20th century, we saw a resurgence of interest in federalism, often referred to as the new federalism.
Okay, the new federalism.
So this movement was driven by a more conservative view of the Constitution, emphasizing a limited role for the federal government, and a greater emphasis on states' rights.
So it was a bit of a counter-revolution.
It was.
A pushback against what some saw as an overreach of federal power into areas that were traditionally the domain of the states.
Precisely. And this shift in judicial philosophy led to some significant decisions that curtailed the power of the federal government and affirmed the sovereignty of the states.
Can you give us an example?
Yeah.
What's a case that really illustrates this new federalism approach and its impact on the balance of power?
A prime example is the case of United States v. Lopez in 1995, which we discussed earlier.
We did.
In that case, the court struck down a federal law banning guns near schools, ruling that the law exceeded Congress's power under the Commerce Clause. So this was a significant victory for advocates of states' rights and limited government. It sent a clear message that the court was willing to rein in federal power and protect the autonomy of the states.
It was like a line in the sand, like a statement.
It was.
That the federal government couldn't just use the Commerce Clause as a blank check to regulate anything and everything.
Exactly. So Lopez marked a turning point in the court's approach to federalism, establishing a more restrictive interpretation of the Commerce Clause and giving states greater leeway to regulate their own affairs, especially in areas like education and criminal justice.
But the court hasn't always sided with the states, right?
It hasn't.
There have also been cases where the court has upheld the power of the federal government.
Yes.
Even when it clashes with state laws.
Correct.
Especially in areas where national uniformity or the protection of fundamental rights is at stake.
That's right.
So the court's approach to federalism has always been nuanced and evolving, reflecting the changing political and social landscape of the nation. So the justices have had to grapple with complex questions about the nature of federalism, the limits of federal power, and the role of the states in our system of government.
It's a balancing act.
That requires careful consideration of the Constitution, legal precedents, and the practical implications of their decisions for both the federal government and the states.
And it's a debate that will likely continue as the court tackles new challenges and confronts emerging issues in areas like immigration, environmental protection, and gun control.
Yeah. Federalism is not a static concept.
No.
It's an ongoing conversation.
It is
a dynamic interplay between different levels of government. And the Supreme Court plays a crucial role.
It does.
In shaping that conversation.
Absolutely.
And ensuring that our system of government remains balanced and adaptable to the needs of a changing nation.
I agree.
So we've explored the court's power.
Yes.
Its history.
Its history.
Its decision-making process. The people who shape its rulings. The controversies it sparks.
The controversies,
and its impacts on American federalism.
Absolutely.
It's been a whirlwind tour. It has. Of one of the most powerful and fascinating institutions in our government.
It's been a journey through the heart of American law and politics, a glimpse into the forces that shape our nation's destiny.
And as we wrap up
this
deep dive, I'm struck by the sheer complexity of the court and the weight of its responsibilities.
Right.
It's tasked with interpreting a document that's over 200 years old.
Yes.
Applying it to issues that the founders could never have imagined.
They couldn't have.
And making decisions that affect the lives of millions of Americans.
It's a daunting task.
Right.
And it's one that the court doesn't always get right.
Right.
But it's a testament to our system of government.
Right.
That we have an institution like the Supreme Court.
Right.
An institution that can serve as a check on the other branches of government. A guardian of our constitutional rights. And a forum for resolving some of the most contentious issues facing our nation.
And it's up to us as citizens to engage with the court.
It is.
To understand its decisions. To debate its rulings.
Absolutely.
And to hold it accountable for upholding the principles of justice and fairness that are at the heart of our democracy.
I couldn't agree more.
Right.
The court's power ultimately derives from the people, and it's our responsibility to ensure that it serves the people, not just the interests of the powerful or the whims of political ideology.
Well said.
Thank you.
So as we conclude this deep dive into the Supreme Court, what are some key insights or takeaways that you hope our listeners will carry with them? What's the big picture message you want to leave them with?
I think the most important takeaway is that the Supreme Court is not some distant, abstract entity.
Right.
It's a living, breathing institution made up of individuals who make decisions that have a profound impact on our lives.
It's easy to get caught up
It is.
in the legal jargon and the procedural complexities.
Yeah.
But ultimately, the court's decisions affect real people in tangible ways.
Absolutely.
They determine who gets to marry, who has access to health care, who has the right to vote, how our government functions.
And those decisions are influenced by a complex interplay of factors. The justices' legal philosophies, their interpretations of the Constitution, the political and social currents of the time, the arguments of the lawyers who appear before them, and even the work of their law clerks, you know, those behind-the-scenes legal masterminds.
It's a reminder that the law is not a fixed set of rules, but an evolving system that's constantly being shaped and reshaped by the forces of history, culture, and ideology.
Absolutely.
And it's a system that we as citizens have a responsibility to engage with.
Understand and ultimately hold accountable.
Beautifully put.
Yeah.
It's been a privilege to join you on this deep dive.
Well, the pleasure was all mine. And to our listeners, keep exploring, keep questioning. And keep engaging with the fascinating world of SCOTUS.
Yes.
Until next time, happy diving.